The Pregnancy Discrimination Act prohibits the discrimination based on pregnancy. And today I will share about the PDA, a critical case before the passage of PDA, as well as the reality after the passage of PDA. The Pregnancy Discrimination Act, PDA, was passed in 1978 to amend the Title VII of Civil Rights Act of 1964. And it prohibits the sex discrimination on the basis of pregnancy, childbirth, and all related medical conditions. And it applies to all aspects of the employment, including hiring, firing, promotion, pay, benefits, including your leave and your health care. And similar as other amendments, it only applies to the employers with more than 15 employees. And there's exemptions. There are exemptions as well. So if it's for elective abortions, employers are not required to pay the medical coverage for this elective abortion unless the mother's life is threatened. But the employers are required to pay, to provide the disability and sick leave for the woman. And one of the important cases before the passage of PDA was Geduldig versus Aiello, 1974. This case involved a pregnant woman who was denied the medical benefits under her disability insurance. And the case cited 14th Amendment and claimed the sex discrimination. And the US Supreme Court ruled that there was no evidence of sex discrimination and there was no violation of the Equal Protection Clause. Ironically, as men and women were receiving equal protection under the insurance program. And because men cannot become pregnant, offering protections for pregnancy would constitute unequal treatment. And the court also didn't consider this case as high importance. There has been a lot of critics after the case, arguing that the physical gender differences should not lead to unequal compensation. And in reality, the effects of pregnancy impact employment decisions in every way. I will share one study on the hiring decisions during employment interviews. Undergrad business students were recruited as interviewers for two applicants. One is a pregnant applicant, one is a non-pregnant applicant. They have identical credentials and same interview performance. And the researchers want to explore whether there are any difference in the ratings of the qualifications of the candidates as well as the hiring recommendations. The results show that the two applicants were viewed as equally qualified and well suited for the job, but the pregnant applicants received significantly lower hiring recommendation ratings. And the pregnant applicant was also rated as more likely to take leaves, to take times off, to miss work, to quit compared to the non-pregnant applicant, indicating that there was a concern for the absenteeism and the turnover. That's the cruel reality of how the pregnancy impacts the employment decisions. This relationship is also strongly related with the maternity benefits you may have. So for profit organizations, if the goal is for profit, they need to control the cost as much as possible. And the better the benefits they have to provide based on the law, the less likely you will be hired or promoted as a pregnant woman. In some way, the terrible maternity benefits in the US, which is 6 weeks of non-paid maternity leave based on the federal law, this may actually help women with the career. What do you think? Share your opinion below.